Welcome to the Eversheds Sutherland Inquiries and Inquests podcast. I'm Catherine Henney, Legal Director, specialising in inquests, inquiries and health and safety. And today's episode is titled, How do you measure the success of an inquiry? I'm joined in this episode by Austin Welch, a barrister from Lincoln House Chambers. In this episode, we delve into the issue of how you measure the success of a public inquiry, particularly from the perspective of victims and survivors and their families. We also look at issues of accountability, what the purpose of an inquiry can be, and how you can achieve those aims. And we also touch on the duty of candour. Austin and I recorded this podcast a few months ago now, but the issues remain as relevant as ever. We hope you enjoy. Austin specialises in inquests and inquiries and health and safety, like me. And you and I, Austin, have spoken at length for a number of times before about this area of law that we practice in, and the challenges we face, but also the rewards we get from working on such cases, and also the learnings that come out of them.
Yes.
Anyone reading the news these days will see that on an almost weekly basis, probably, there seem to be new calls for public inquiries to investigate perceived failings or issues of significant public interest. So, just recently and locally for us, we've had inquiries announced into Lucy Letby, the nurse who was convicted of murdering a number of babies in Chester, and also looking into her actions at Liverpool. And also Andrew Malkinson, who was recently released from prison, having served 18 years for a crime he didn't commit.
Yes.
So the title of today's podcast is about measuring the success of an inquiry. But I think that in itself probably raises the obvious question, well, it depends on whose perspective you're looking at it from. That if you have any inquiry in the first place, something has gone wrong.
Yes.
And it's usually something catastrophic or there's been deaths involved. But there can also be sort of independent inquiries, non-statutory inquiries, such as the Telford Child Sexual Exploitation Inquiry, which was one that I worked on, where, you've still got victims and survivors, even though you don't necessarily have, families of deceased.
Yep.
But in all cases, whatever the issue at play is, there are going to be groups of core participants or victims and survivors, or however you term them, that will have very clear aims and objectives of what they want to achieve from the inquiry itself. And from your experience working on public inquiries, what would you say is perhaps the overriding sense you get from victims and survivors and from the family perspective for what they're after?
I had the privilege of working on the Manchester Arena inquiry when I represented 3 family groups in that public inquiry that went on for some time. And it's probably fair to recognise that in any public inquiry, everyone starts from the position of having some knowledge, but not a huge amount of knowledge. Mm-hmm. Nobody knows all the evidence that is going to be heard. Nobody knows all the issues that are going to be considered. Even when you have the terms of reference established, there are going to be a number of discrete and often very important issues that are going to arise during the course of that public inquiry. And it's correct to view a public inquiry as being really an investigation, where you start at the outset, and for everyone involved, you are learning. In relation to family core participants in particular, you can't say there's one or even a few things that all family core participants are going to want to focus on in a particular inquiry. You're going to have a number of different interests. You're going to have a number of different family core participants that will be involved to varying degrees in the public inquiry. Some are going to want to be at the forefront and involved in every single part of it. Others are going to want to take more of a backseat role. There was one question that I think families want answered in a public inquiry, one issue that's the overriding issue. It's an answer to the question of how was it that this terrible event happened to my family member?
Mm-hmm. Yeah.
How was it? And I go back to the Manchester Arena inquiry. An event like the arena bombing does not happen in a vacuum. In that case, a number of the family members had sat through the trial of Hashim Abedi. And so they knew at the outset of the inquiry that it was the Abedis who had planted the bomb. The Abedis who had decided and planned this attack. But they also knew that that was only one part of really the wider picture. There was a very genuine concern that the Abedis had not acted alone, that they'd had at the very least support from others, and that was addressed during the public inquiry. But there were also wider issues that, of course, hadn't been explored as part of the criminal trial. Issues in relation to the security and safety of the arena and the surrounding area. Issues in relation to the emergency response, and that had partly been addressed by the Kerslake review, but not in the detail that you get in a public inquiry. Issues in relation to the security services, which is inevitable in a case like that, and what they knew. And issues in relation to the Abedis' radicalisation generally, how it was that these two young men from Greater Manchester had gone down the path that would ultimately lead to these terrible events. And so they had a number of questions that no one had really addressed, all of which lead into this overall question, how did this happen? But there were a number of subtopics that arose from that.
And I think that, just listening to you talk about that there are a number of parallels that come out when you look at, for example, Grenfell Tower.
Yes.
And that, a lot of what was reported afterwards, understandably, what we all learnt in terms of, the ultimate causes of what happened is that, how was it allowed to happen? Yes. How were these things allowed to happen by whoever the party may be, the tenant management organisation or whoever it might be? How was it allowed to happen when certain things were known about or could have been acted upon earlier? And so my sense is that what is also important is accountability, and certainly you feel that, and I don't think anyone can have avoided feeling that, using Grenfell as an example of all of the campaigning that went on as well alongside the inquiry. And we still get every year when it's the anniversary of the night itself. So, what would you say about accountability? Because all of those elements that you spoke about from the arena bombing's point of view is, yes, you look at the Abedis themselves and them choosing to do what it was that they did, but all of the areas around that in terms of allowing, how were they allowed to carry that out when you look at those other parties and the responsibilities that they had? I'm not asking you to comment specifically on those, but that is another theme that I always think is clear when we have any kind of inquiry, is that people are seeking some accountability for whatever's gone wrong. I
think that has to be right, and I think that if you look at the families of victims of an attack like the arena, a terrible tragedy like Grenfell, it's not enough just to determine facts as to what happened. That will only take us so far. Because if you do consider that one of the principal purposes behind a public inquiry is to learn lessons, the fact-finding will take you so far. But underlying any fact-finding exercise, there have been decisions that have been taken. There have been steps that have been taken by various individuals and organisations that have led to those facts, that have led to the terrible disaster. And so holding people and organisations to account so that they can explain, justify any actions that they did take which might have resulted in the disaster is important for those families that have suffered these terrible tragedies. They want to hear why people did what they did, what should have been done, what could have been done differently, why it wasn't done differently, and how it's changed, of course. And so for the families as well, knowing that there have been changes and there have been lessons learnt is important. But I also think it's important, accountability is important for the wider public as well. Because we put a lot of faith in the system of public inquiries in this country. As you said at the outset of this podcast, it's hardly a week goes by before we hear some new public inquiry being discussed. And the immediate reaction of the government, the media, when there is another big disaster, is to consider whether there should be a public inquiry. Well, why? Why do we have a public inquiry into all these things? It's because it's considered the best way of looking at what happened, exposing it in public, and bringing people to account in a non-adversarial, non-litigious environment so that we can learn lessons for the future. And I wouldn't expect the members of the public would in any way be satisfied following events such as Grenfell, the Manchester Arena, and you can go back to the various other public disasters, if we simply had a system whereby a report was published saying this is what happened. These things happen because of the actions of individuals and organisations as well, and what they have done since is going to be important.
Yeah, and I think and there's an interesting point you said there about, exploring it in a non-adversarial sort of process. But of course, actually, some may say, well, accountability rightly deserves some adversarial process in the sense that somebody should be prosecuted or held to account. And then, so if we go back and look at Hillsborough, for example, which remained as an inquest ultimately. You had the inquests ultimately, an earlier inquiry, I know, but ultimately as inquests, and the individual prosecutions. So one might say, if I'm to be objective or perhaps controversial, say, well, you've got the inquest that deals with the fact of the deaths and the family, which is not supposed to look at accountability because that is not to find blame, that is to explore, the causes of the deaths. And then you have prosecutions of individuals or organisations where necessary to hold people criminally to account for failings. So where is the need in that? If you have those avenues, where is the need then to also have, at great public expense, a public inquiry?
In terms of the criminal prosecution that might follow one of these terrible incidents, it's going to be the nature of that criminal prosecution that any defendants will primarily want to defend their position and limit any exposure that they will have for any criminal liability and any following on civil liability. So they're not going to approach a criminal trial ordinarily in the spirit of identifying what went wrong and what they could have done differently. That's just not how the system works in this country of criminal prosecutions and indeed civil proceedings. And it would be artificial and unrealistic in many ways to expect that to happen. I think the system works well for public inquiries because there is that ethos of learning lessons, and there is that belief that organisations, particularly public organisations, will approach these statutory and non-statutory inquiries in the spirit of themselves understanding what happened. And themselves understanding what happened so that they can make effective change so that it doesn't happen again. Because the one thing that these organisations and any organisations and the public doesn't want is a repeat of what happened last time. Nobody wants a repeat of an incident such as Hillsborough. Nobody wants a repeat, if possible, of an incident such as the Arena, although we know the very real terrorist risk that still exists. But whatever we can do as a society, and whatever public bodies and corporate organisations and indeed individuals can do to keep us safer, so that it's not another family that's put in the awful position that family court participants are put in a public inquiry having suffered so terribly. Whatever we can do is worthwhile. And there's always, in my time doing public inquiries and some of the bigger inquests, been discussions about whether there is a duty of candour on public organisations when they approach a public inquiry or inquests. Now, there's no statutory duty of candour, say, for the NHS in certain circumstances, albeit there is a lot of discussion as to whether there should be a statutory duty of candour. But it's my opinion, having been involved in a number of public inquiries recently and the larger inquests, that there's an expectation of candour. And there's an expectation of candour from the chair, from other core participants and interested persons, particularly the families, and also from the public. Mm-hmm. I think that the days when an organisation could look at a public inquiry and think, right, we're going to take a very, very defensive, litigious approach to this because we're worried about what might happen, have long gone. Mm-hmm. I think that organisations that try and adopt that approach will quickly find themselves the subject of criticism because it's quite obvious when it's happening as well. It's not what these inquiries are meant to be doing, and ultimately it's of no benefit to wider society and even themselves. So I think that increasingly, when one looks at what can be achieved at a public inquiry, I think it's a great deal more than if you simply did have a system whereby after one of these events it was considered appropriate simply to proceed to potentially litigation. If you do that, you might save money. No, you would save money in terms of the cost of these inquiries, but you're not going to actually achieve any change.
Yeah.
And it would be it's an awful thought, isn't it, to think if we learn nothing from any of these incidents and then it happens again.
Yeah, absolutely. And I mean, I think that is a fundamental measure, really, certainly in my view. And you talk about the duty of candour, which again is back making headlines again when you think about Lucy Letby and the duty of candour, because that came out actually from the Mid-Staffs Public Inquiry, which was one that I spent years working on with Sir Robert Francis, and you know, that was one noticeable change to come out of that particular inquiry. And from your point of view, I guess you would say what can actually change if you look at Manchester Arena. Similarly, it's the protect duty.
Yes, absolutely.
And so maybe that would be something you could talk to us a little bit more about that, because that again was led by Martin's family, I believe, or that became known as Martin's Law and is still talked about Martin Law. But that is another perhaps real change or marker of success, one might say.
I think that's right. Martin's Law, as it's now commonly referred to, was driven by Martin's mother, Martin Hett's mother, Fegan Murray, who I didn't represent, but I did represent Martin's father. Mm-hmm. So knew the family, got to know the family fortunately quite well. And it is, again, perhaps going back to what are your objectives at the outset. And when representing family court participants, there's going to be a whole range of different objectives and aims and what they hope to achieve during the course of the inquest. It was very much right from the outset of the Manchester Arena inquiry obvious, because everyone knew about it, that one of the aims was to try and achieve some change in legislation so that there would be the protect duty, whereby businesses would have to factor into their risk assessments and planning of large events, or events generally, the terrorist risk. And so that was clearly a focus of those core participants in those proceedings. That's just one element of what families might want to achieve. There'll be other things. And I think that's probably the extreme, if you think about it, because it was a very clearly defined objective. This is what we would like to achieve. We would like to see some change in the law that will force companies and organisations to take into account this matter and actually introduce measures to combat the terrorist risk. For many of the families, it wasn't quite as clearly defined, the objective, as that. It was more a case of, as I said, trying to just understand what happened. And as the inquiry went on, they started to understand new and different things in relation to what had happened. One of the interesting elements of the Arena inquiry was the development of the issue, which is known as the care gap.
Yeah.
Now, what the care gap was is the period between when there is an incident, a mass casualty incident, and when the emergency services can actually get there, and there is a period of time nothing can be done because they're simply not there. And that was a matter that nobody had thought about at the beginning. And it occurred during the course of the inquiry and became one of the most fundamental issues in terms of the emergency response, and one of the most important issues, and perhaps one of the issues in which the most change has been made. And there was expert evidence called upon it, and it was subject of recommendations. But I think that is a very good example of, you can have some objectives, such as Martin's Law, clearly defined objectives, and that is what people want. And in the inquiry, in the Manchester Arena inquiry, it looks like that will have been achieved now, which is an enormous change that's been affected. But there will be other objectives that people have right at the outset, and they will change as the inquiry goes on.
Yeah, and I think that's an also very important difference between an inquiry and an inquest.
Yeah.
If we look at the fact that an inquest is very specific in terms of the 4 statutory questions that have to be answered, that the coroner has to answer, and there's no real flexibility beyond that, apart from perhaps an extension of the how somebody died, if it's appropriate to do it in what's known as an Article 2 inquest. And the reason perhaps that many inquests, when appropriate, do convert into inquiries is because there isn't that level of flexibility to allow them to look at changing evidence that comes out, as you've just described. So that, where you have issues that come up during the course of an inquiry, you are able to, as a chair, or within the terms of reference, adapt and explore that avenue in a way that would not be possible in an inquest, perhaps. I don't know if you would agree with me on that one, but
I do. And the Arena started as a series of 22 inquests and was converted before any of the hearings started, during the pre-hearing period, because of security reasons, where certain evidence couldn't be heard. So it was converted to a public inquiry. And so that begs the question, well, in terms of what the family's objectives were in understanding what happened, hoping that there will be change, hoping that there will be legislative change, holding people to account, did the fact that this was a public inquiry achieve those aims more than if it had been an inquest? And we'll never know, because we don't know what probably would have been the jury would have found in an inquest. But I agree with you completely. In an inquest, you are limited by the 4 statutory questions and how, if Article 2 had been engaged, how and in what circumstances the 22 people died. There's a degree of flexibility in an inquiry, but you can look at issues which are going to be outside the normal scope of the inquest. Issues that have arisen as a result of what happened at this terrible disaster, which are not causative of any of the deaths, but are a matter of public concern. They can be addressed. The other issue in terms of achieving the objectives of the families, whether it was better an inquiry or an inquest, in my opinion, there's no doubt that a jury would not have been able to deliver such a comprehensive and analytical set of conclusions as Sir John Saunders and his team produced in the 3 volumes of their report, running into hundreds and hundreds of pages. A jury can't do that in an inquest, and it would be artificial to think they could come close to doing that. And so my own opinion is that almost certainly in achieving the aims and objectives, the statutory inquiry was a better way. It was helped by the approach that was adopted by counsel to the inquiry and Sir John Saunders in the Manchester Arena inquiry, because they were very keen to ensure that the families remained at the heart of the inquiry itself, and not just them as core participants, but also that they could take part in the inquiry. So we, as their lawyers, were still allowed to ask questions, and were much more involved in the examination of witnesses, which enables us to ask the questions directly and more quickly that our family clients might have. So yes, I do think that is an important difference in achieving the aims of the family.
I mean, I think that, and just hearing you talk that through, it almost shows we're coming full circle back to the beginning of this podcast, where we said, how do you measure a success of an inquiry? You've just given examples there of how success will look very different depending on who you represent.
Yes.
And that's what we sort of said. It depends whose perspective you're looking at it from. And I think, and just drawing this conversation to an end, as much as I don't want to, because we're having a great time chatting, I think the full circle nature perhaps of what success looks like has come apparent to me from us talking, and I've just been noting down some of the words that have come out and what I almost see as the full circle of success, or how one might measure success. And I've written down reflection, leading to learning, leading to truth, leading to accountability, leading to change. And you could put in there as well candour, because that was another one that came out. So those things, reflection, learning, truth, candour, accountability, change, are all aspects, I think, that encompass what we've talked about today, and what any party would probably say, depending on which side you're coming at it from. To some degree, those will touch upon success from any participant, or the public at large, really, what we want from an inquiry.
Yes, I think that must be right. I think that, as we've discussed, the one thing that you want a public inquiry to achieve is not simply to have a series of junior employees who, often working in very difficult circumstances, have made individual errors. That's not the purpose of an inquiry. The purpose of a public inquiry has to be to make such effective change in systems, procedures, in the way people go about their business and carry on, that these terrible events won't happen again.
Yeah. And that's got to be the ultimate
success,
the ultimate, is that they don't happen again.
Absolutely.
Great.
Yeah.
Well, I'm really grateful for you taking the time to come talk to me today.
Not at all, thank you.
And I look forward to us catching up again very soon. All right.
Thanks very much.
Thank you, Austin.
Bye-bye.
Thank you for listening to the Eversheds Sutherland Legal Insights podcast.